Stuart Clark, thanks for your time today. The Law Council's criticism of Dyson Heydon, is that essentially aimed at what Labor has been saying?
Look, it's not aimed at any one political party or any one person. I should make that very clear at the outset. We're concerned about the approach that's been taken to address what is obviously a difficult issue. We say, quite simply, that the personal attacks, the attacks on the integrity of the Commissioner, the attacks on essentially going to the honesty of the Commissioner are inappropriate. There is a very clear process by which a person who believes that the Commissioner is either biased or there's an issue of apprehended bias, there's a very clear process to follow, and that is what should happen. The sorts of attacks that we're seeing in the Parliament, the sorts of attacks that we're seeing in the press are simply inappropriate, and they're dangerous at the end of the day.
Labor has said essentially that its motion in the Senate it's going to hold off on until the decision is made on Friday. Is that fair enough? Are you welcoming that move?
Oh, look, I think that's exactly the right decision. I had heard that that was the case. They are to be congratulated on making that decision. The process for dealing with a question or a suggestion of apprehended bias is to go to the tribunal, to go to the Commission, to ask the Commissioner to consider the matter, to place the evidence which the applicant wants to rely upon before the Commissioner. The Commissioner that can then rule on the issue, and if the parties or the moving party is dissatisfied with the outcome, then there's a very clear appellate process or review process. That's how courts, tribunals and royal commissions operate. These are not matters which should be tried in the press. These are not matters which should be the subject of partisan debate in the Parliament. Another
thing that's been mentioned is some quotes from Dyson Heydon in some of the rulings he's made in the past, and he's spoken about not just a conflict of interest but even the mere perception of it. Is that sort of standard going to be applied here? We're talking, for example, about the Liberal Party event that he agreed to do assuming that his time as Commissioner would be over. Do you think there's enough there for this perception of a conflict of interest?
Well, I'm not going to comment on whether I think on the basis of press reports there is or isn't enough. The test is well established. The question that must be asked is how would a fair-minded lay observer react to that material? That's the test that has to be applied. That's the test which the Commissioner himself has referred to in his judicial decisions. That's what will be considered. There has to be a careful and a dispassionate review of what actually occurred and what actually was said. And one of the dangers of the sort of, in some respects, hysterical debate that we've seen in some parts is that the issues become confused, the issues become clouded. Let's go back to what actually occurred. Let's allow the Commissioner to apply the test. Let's allow the process to run its course. And I would like to make one thing perfectly clear. This is not a partisan view being expressed by the Law Council. The Law Council has taken this view in relation to comments that have been made by the Prime Minister in relation to decisions of the courts. It's been taken in relation to a range of commentators speaking or commenting on the work of Professor Higgs in relation to the President of the Human Rights Commission, Professor Triggs. We simply don't want to see the debate in relation to the questions of bias or questions of partisanship being reduced to personal attacks on individuals. These people are discharging, in the case of Professor Triggs, her statutory duty. In the case of the Commissioner, his duty as the Royal Commissioner. The jobs that these people are given, the role of a Royal Commission is incredibly important. Issues of great national importance have to be considered by Royal Commissions. Think of the stolen generation. Think of the current Royal Commission that's going on in relation to child abuse or the response to child abuse by institutions. These are matters of fundamental importance to the community, and it's critically important that nothing be done which damages the community, the public's perception of how these organisations operate, how inquiries are conducted. That's why we have these procedures for dealing with issues that come up. That's why we should be following these procedures in this instance.
How standard is it for the intervention that Dyson Heydon did make when Bill Shorten was on the stand, talking about or questioning or being concerned about his credibility as a witness? Because this seems to have been something that's really got under Labor's skin. Is that a standard judicial intervention, if you like?
Look, Judges will often comment on the way a witness is answering a question. Judges will often encourage a witness to be more responsive. Now, I don't, in saying that, make any comment in relation to Mr Shorten's comments or in relation to what the Commissioner said. But let me make this point. If in fact there was a concern that this was evidence of bias or that it gave rise to a question of apprehended bias, the appropriate response would be to make an application in relation to that issue. It is not appropriate to then debate that issue in the media in the context or in the form of fairly personal attacks on the integrity of the Commissioner or the bias, alleged bias of the Commissioner and in his discharge of his duties. If there's an issue, if there's a concern, there is a very, very clear process. And what the Law Council is saying is that that is the process that should be followed.
Okay, and just finally, if the process, that application process, is not something that gets, from Labor's point of view, from the union's point of view, the outcome they want, would you then say it is acceptable for Labor after that to move this motion in the Senate to try to have this motion passed that asks the Governor-General to revoke the Commissioner's role?
No. The appropriate response, if a party or an applicant to that application is dissatisfied with the outcome of the application to the Commissioner, there is a very clear process which they should pursue through the courts. That's why we leave it to the courts to determine these issues. It should not be resolved by way of a partisan debate in the Parliament. It should be resolved by the very, very clear, well-established processes we have for dealing with these issues.
Stuart Clark, thanks for your time today.
Absolute pleasure. Thank you.